Good morning, everybody. I'm glad you could join me here to talk about capacity mechanisms. Just to quickly walk you through the content of this webinar. The introduction part explains what capacity mechanisms are and why they are much discussed at the European level. The main part will focus on how EU law treats capacity mechanisms. Lastly, I will draw some conclusions from this approach and then try to answer any questions or comments you might have in the Q&A. It is perhaps a good starting point to define what we understand under capacity mechanisms, or as they are fully called, capacity remuneration mechanisms. Capacity mechanisms are introduced by the state to pay generators for their capacity. Now, the important thing is to understand that capacity is not energy. It is availability of energy. In other words, it is the energy that a generator commits to produce at some point in the future. Usually, generators are paid only for energy they sell in the market. This is what we call energy-only market, because energy is the only product. If a capacity mechanism is in place, then the generators are compensated for both energy and capacity. So this becomes a two-product market. Now, why would we need capacity mechanisms? Well, capacity mechanisms are introduced to encourage generators to invest. If energy prices are low or generators don't produce as often as they would like to, they might not be able to recover their investment costs. And this is a very capital-intensive sector. So capacity mechanisms provide these generators with an additional stable stream of money on the top of the revenue from electricity trade. Another more recent problem is caused by the implementation of RES target. More and more renewables on the system calls for more flexible conventional generation, which could produce when there's no wind or the sun is not shining. This slide is just to show you that capacity mechanisms in Europe are nothing new. And that we have many different types of capacity mechanisms. We will not discuss them here in detail, as this is beyond the scope of this webinar. If you are interested, we have 2 other webinars on capacity mechanisms, which cover this topic. I will refer you to these webinars in my last slide. But as you can see from this map, some countries are implementing capacity mechanisms right now, or are revising their old schemes. And these are new developments, which just couldn't go unnoticed at the EU level. From the EU perspective, the concern is that if there is no coordination or control over the schemes, they might distort competition. They might affect cross-border trade and undermine the whole EU energy market model. Before we move on, I would like to run a poll on a question which we will then focus on in the next part of this webinar. The question is, which EU provisions may apply to capacity mechanisms? As you can see, there is a number of answers, and you can mark as many of them as you want. This is just to trigger some thinking about what we'll be discussing next. So I will launch this poll now. Okay, and we maybe now leave some time for you to answer. Okay. That there are some late arrivals here. Okay, Ricardo, I think we can close it now. Okay. Okay, I hope you all can see the results. Because yeah, I think you can all, yeah, okay. So these results are interesting, but I prefer not to comment on them now because we will talk about this in this main part of the webinar. And so I think we will come back to this question at the end of the webinar and go through all the answers. This is just an overview of main EU policy documents that are important to capacity mechanisms. Back in 2012, the Commission opened a consultation. The idea was to come up with a set of criteria for designing capacity mechanisms so that they don't undermine the internal market. In May, the European Council called the Commission to do something about capacity mechanisms. And the Commission met this call in November. It issued a communication which, among others, was dealing specifically with capacity mechanisms. Throughout this process, the Commission was open about the fact that capacity mechanisms are likely to be subject to state aid rules. That this is not surprising, as depending on how a capacity mechanism is designed and how it is financed, it can involve state aid. Also, at that time, the Commission started a very important reform of state aid control. This included developing new state aid guidelines for the energy sector. So it was a perfect opportunity for the Commission to include capacity mechanisms in this new guidelines. Not surprisingly, all the thinking developed in the consultation on capacity mechanisms and then in the Commission's communication fed into this new state aid guidelines. The first and so far the only case where the Commission applied these rules is the approval of the UK capacity market. More state aid decisions are likely to follow. As we can see, state aid rules are currently the major instrument of EU law when it comes to capacity mechanisms. However, European energy sector is governed by the third energy package, and that should be our point of departure. So let's have a quick look at this legal framework. In fact, Electricity Directive regulates investment in generation capacity. According to Article 7, new generation capacity must be constructed through authorization procedure. That's fine, but this assumes that there are and will be investors who are willing to construct new generation. But what happens if nobody wants to invest? Well, the directive foresees such a situation. Member states can intervene for security of supply reasons if the authorization procedure fails to secure sufficient levels of investment. And here are the options. First, it can organize a public tender for the construction of new capacity, or it can resort to any other measure which is equivalent in terms of transparency and non-discrimination. It means that a member state can set up a capacity mechanism for security of supply reasons, provided that it is transparent and non-discriminatory. It can also impose, also for security of supply reasons, public service obligations, and that's Article 3.2. Now, what are public service obligations? Well, the state imposes such obligations on companies to perform services which are important for the society, but which would not be performed under normal market conditions. Moreover, the state enjoys a wide margin of discretion in classifying certain activities as public service obligations. The possibility is important because once something is classified as a public service obligation, the compensation for the service might more easily escape the state aid box, as we will see in the next slide. Then, in that case, the Commission's control over financing this service is much more limited. So, just to recap, if security of supply is at risk, the state can go ahead and set up a capacity mechanism, provided that it is transparent and non-discriminatory. Similar language we can actually find in the directive on the security of electricity supply, which allows both for the imposition of public service obligations and measures which ensure sufficient reserve capacity, as long as they are non-discriminatory. But when capacity mechanisms are actually state aid, for capacity mechanisms to be state aid, there must be 4 conditions which needs to be met, and those 4 conditions are set out in Article 107. So there must be economic advantage, which must favor certain undertakings. So not only it must be given to an undertaking, but it has to be selective. Then it must be state-funded, so either through state resources or there's a link to state resources. We'll explain that later. And finally, it must distort competition and affect cross-border trade. Most importantly, the form of the mechanism is not that important. No matter how the scheme is called, once it meets these 4 conditions, then it is in the state aid box. The 2 last conditions are easily met. So we will focus on these 2, state resources and economic advantage. State resources is a very wide concept, and it would be difficult to create a capacity mechanism which does not involve state resources. Even if the money is not coming directly from state, but let's say from consumer's pocket, it can nevertheless meet this condition. If there is some sort of state involvement, or at any point of time these resources are under public control. So the origin of resources is rather irrelevant. What matters here is the degree of state intervention in this mechanism. What about capacity markets? For instance, France, when designing its capacity market, argued that there are no state resources involved because the state just organizes the transfer of private resources. It creates a market mechanism, and that's all. That there's no impact on the budget. Well, no. Case law shows that if the state creates an asset and give it free of charge, these are also state resources, because the state could have sold this asset and made some money instead of just giving it away for free. Economic advantage. Also, okay, so state resources can be also this condition can be likely met. When we talk about economic advantage, this is also very, very wide. It doesn't need to be money. It can be any economic benefit that a company would not enjoy in a normal course of business. However, if the state imposes on an undertaking a public service obligation and compensates it for the cost of the service only, there is no economic advantage, and there is no state aid. This is an important exception. The Commission uses here the so-called Altmark test, which is basically to make sure that the public service obligation is valid and that there is no overcompensation. Now, let's assume that a capacity mechanism meets all these four elements of state aid, and the state imposed no public service obligations. In principle, state aid is compatible with the common market. In principle, the state aid is incompatible with the common market, and therefore it's not allowed. However, there are many exceptions to this general prohibition. Many forms of aid are automatically exempted, whereas other types of aid need to be notified to the Commission for approval. And this is the case of capacity mechanisms. So if the state has to, the state has to file a notification, and the Commission checks whether the given mechanism is compatible with the common market using the criteria which are set out in the new energy guidelines. What are these criteria? The guidelines contain general assessment principles, which are there further adjusted to capacity mechanism in a separate section, which is dealing specifically with aid to generation adequacy. This all criteria are in the guidelines. So let's maybe keep it short here. Looking at the Commission's decision on the UK capacity mechanism, we can say that the participation of cross-border capacity and demand-side response are important criteria for this compatibility. However, the participation of generators located abroad should be taken into account only if this is physically possible. And the obligation to deliver capacity cross-border can be enforced. This means that foreign generators can be actually excluded from the capacity mechanism if the state demonstrates that including them is not possible. Either because there's no sufficient cross-border capacity, or it would not be able to sanction generators located abroad who fail to deliver this capacity. Let's maybe sum up this approach. So on the plus front, state aid control gives the Commission an opportunity to intervene before the state implements the mechanism, and the state cannot implement the mechanism until the Commission approves it. That's the so-called standstill clause. The procedure is based on negotiations and also allows for informal contacts between the Commission and the state even ahead of the formal notification. In that sense, the Commission can play an active role in shaping the proposal for the mechanism. One can even draw here a comparison to Article 9 commitment procedure under antitrust rules, where the Commission sometimes seems to act more like a market regulator, not a competition authority. The states benefits from this flexible, negotiated approach insofar as the Commission takes into account various country-specific circumstances and can agree to solutions that are matching the interest of the state. Another observation is that if the state is ready to give concessions and adjust the mechanism, the procedure can be pretty fast. The approval of the UK capacity mechanism took the Commission only 1 month. However, one can assume that there was much negotiations going on in the pre-notification phase. However, not all state aid cases are that quick. In fact, they might take up years, and this is not good for investors. Also, if a state faces a generation gap in 2-3 years, it needs to act quickly, and this route is not the fastest one. Obviously, a lot depends on the approach of the state, how much changes it is ready to accept to get the Commission's approval. But it also depends on the clarity of the compatibility criteria. If they are not clear enough, then member states might prefer to rely on models that have been approved by the Commission in the past. Well, for instance, in Poland, there is now some discussion about introducing a capacity mechanism. And the Polish government is talking more and more about implementing the UK model, since it got a green light from the Commission. So if the energy guidelines are not precise enough, there's some risk of copy-pasting, which might not be the best practice, given that we talk about very different markets. And now, are there alternatives to state aid control? Well, the Commission could start an infringement procedure against a member state for non-compliance with EU law. And there are several potential provisions that could serve here as a legal basis. This could be sector directives, but also treaty provisions on free movement of goods or fiscal barriers to trade. However, this can be also a very long route, especially if the case is taken to the Court of Justice. Another drawback is that the Commission can start this procedure once a capacity mechanism is actually implemented. If a capacity mechanism is so designed that it enables market manipulation or other abusive practices, it can be subject to antitrust rules. Remit provision might also apply to potential market manipulation and insider trading, which relates to the capacity market. Having said that, let's maybe come back to our poll question. So, third energy package, security of supply directive applies, as we have seen from the legal framework. They both allow for this type of mechanisms as long as they are transparent and non-discriminatory. The second answer is wrong. It is settled case law that restrictions on the movement of all forms of energy are caught by the treaty provisions of goods and not those relating to services. Big green tick next to state aid rules. Finally, remit regulation may apply in cases of market manipulation or insider trading, and antitrust rules can also be enforced. Thank you very much for your attention. I hope you found something useful in this presentation. As I already mentioned, I would like to draw your attention to two other webinars on capacity mechanisms. First, there's a webinar of Carlos Batier. Carlos provides a very good introduction to this topic, as he talks about capacity mechanisms from a broader regulatory and market design perspective. And then we have a more recent webinar from September this year, in which Arthur Heniot presents his research paper on capacity mechanisms and generation adequacy. Both webinars are now available on YouTube. Here are my contact details. I'm happy to discuss this topic with you either now or whenever you feel like. Just get in touch if you have comments or questions. Thank you.
Okay, Gosha, thank you very much. And in fact, I think we can start discussing the topic now, as we received a lot of questions. So if you're okay, I will share your webcam with all the audience, and we can start with some of the questions you received. Perfect, we can now see you, all of us. Good. So the first question we got is about the UK system. And it is the following. Stated clearance has been granted for the UK capacity mechanism on the provision that it can accommodate interconnectors and interconnected capacity from the auction 2015. The UK government has opted for the participation of interconnectors owners in the 2015 auction. This is intended to be an interim measure until a cross-border solution is developed, but it looks as if this cross-border solution is some way off. In your view, will the participation by interconnectors owners distort the internal energy market? one could argue that they have a conflict of interest with these dual roles.
Is it a poll? Can I choose? No, thank you very much for this question. The safe answer would be it depends. It depends on how this capacity market is designed. As far as I know, this will be a competitive bidding, and interconnector owners in this this intermediate solution. So there won't be any option. It's not feasible to allow direct participation of generators located abroad, but the interconnector owners can bid in this auction. And they will bid on equal footing. They will bid on equal terms with domestic generation. I think like the only difference is that there will be some sort of algorithm, the rating algorithm in place, but otherwise the conditions are the same. In that terms, well, I get your point about this double role I get your point about this double role of the interconnector owner, who is by definition also transmission system operator. But I would say that in every market there must be mechanisms in place that should be able to mitigate any abuses, any abusive behavior, any instances of market manipulation. We have REMIT, we have antitrust rules. If those mechanisms are efficiently enforced, then I don't see that would be a great problem, especially that if we think electricity markets and energy markets in general are specific in terms that this conflict of interest is always present, or it's very often present. And there are mechanisms set up which mitigate those risks. Maybe just in terms of distortion to the internal energy market, if we not allow cross-border capacity to bid in these actions, then I think the distortion is even bigger than if we make sure that there will be no conflict of interest between the organizer of the auction and the bidding party. So I think that there is we have some bigger objective in mind, and any risks of abusive behavior can be mitigated by other mechanisms.
Okay, thank you. That's clear enough. And just to complement on this answer, a very short question, which is what can the Commission do if the UK government doesn't keep its commitment to include cross-border capacity? Can it revoke its decision?
Well, actually, what the Commission can do in that situation is to It can, for instance, launch for formal investigation if the state aid which has been cleared by the Commission is in some way misused. So that's one way of dealing with this, but that's very adversary procedure again. So I think that what the Commission could do instead is to there's even an obligation on the Commission imposed by the treaty to monitor all existing state aid in all the countries in cooperation with those given countries. So I guess that the solution here is more like the solution is a bit more about negotiating and finding a way why the state is actually not keeping its commitment.
Okay, clear. So as we have today, we've had more than 120 attendees from several different countries. Now we have a question from a different country regarding a different system. As you mentioned, the Polish government is thinking of introducing a capacity market. The question is, if it will be based on the UK model, will it be open to interconnectors and demand response?
If there are any Polish people out there who will not agree with what I would like to say now, then just don't be ashamed, raise the hand. But in the first place, to be frank, it's pretty much of a debate in Poland now. As far as I know, there has been no official stance from the government on this. Like no official proposal to implement a capacity market and then that it would be that it would be based on the UK model. I think that right now, if I'm not mistaken, there's a study or a report made by Ernst & Young. I think it was commissioned by the Association of Generators. And that's the proposal which was put forward to the government. And this proposal then analyzes two options. One is the UK model with a centralized auction, and the other one is the French model, so a decentralized market. And the preferred option is the UK model, not only because it's just simpler to implement, but also because it got the green light from the Commission. But in my opinion, I mean, this discussion on capacity markets in Poland has been going on for many years. In the 90s, we had long-term energy supply contracts, right? So they were they were giving generators some sort of security. But once the market was liberalized, the Commission said that those contracts are illegal aid, and they had to be removed. So that was in 2005 to 2006, and the discussion about setting up a capacity mechanism started in 2008 when the economic crisis kicked in, and the prices dropped, and there was overcapacity. So then the industry started to complain. And now we have 2014. The capacity market is still not there. I remember last year the Polish transmission system operator was warning that there will be that we will have capacity shortage starting from 2016. Now it says it will be after 2020. So I think that this discussion is just it will still take a lot of time. I frankly speaking don't believe that we will set up a capacity mechanism, especially if we are looking at the Polish legislation. Setting up a capacity mechanism would require changes to legislation, and we are still waiting for our reform of the energy law, and it's not, and it has been taking years. So yes, that's my view. If just in abstract, if there would be a capacity mechanism in Poland, I don't think it will be open to cross-border capacity. That's simply because we don't have we don't have enough cross-border capacity. So I'm sorry to be so negative here.
Okay, no, it's clear, a very complete answer. Now, I would like just to conclude with a final question, as we are running out of our schedule, but it's very interesting because we have received 4 questions on the same topic, which is France. Basically France and the general approach of the European Commission. So we've spoken about the UK and Poland, and so some of our attendees want to know the status of approval of the capacity mechanism in France. And to relate it to this, there is another comment. Doesn't it look like the European Commission is taking a rather indulgent or too soft approach to capacity mechanism? So if we could give a short answer to this.
Mm-hmm. Well, in terms of France, from what I heard, that it wasn't formally notified to the Commission because France argued that it actually imposed a public service obligation. So I think that the French government all the time, I think, like, this capacity mechanism was also has been also been implemented for a long over a long time. I think it started in 2010, and now I think this year it's supposed to be introduced. So I think from what I heard, the French government was all the time in touch with the Commission about this, and it was also argued that it was actually arguing, as I mentioned in the webinar, that it falls out of the state aid box just because it doesn't involve state aid resources. I think that claim might not be valid, but it's likely that this public service obligation argumentation would work here. So I think the mechanism is allowed. In terms of it's true that we have now the only one state aid decision approving the UK capacity mechanism. So it's very hard to now judge what is the Commission's approach on the basis of this one decision. I think that since capacity mechanisms are allowed, and since security of supply is still a very national issue, then what the Commission can only do is to have an impact on the design of these mechanisms. So what I can foresee is that there will be many that type of Commission's approvals, but obviously with commitments from the member state to make those mechanisms as competitive as possible, open to cross-border capacity where possible, and open to demand side response. So I think that would be the approach. It's one can call it soft, but I think that's the only possibility the Commission has now.